Good afternoon to those of you on the East Coast, and good morning to those of you on the West Coast. My name is Felix Shipkevich, and I am humbled and excited to be co-hosting today's webinar discussing the regulatory and legal considerations for debt settlement companies' oversight of front ends. I'm joined by my colleagues Jessica Livingston and Yvonne Bowser Caballera. Thank you for joining. A little bit about myself. I am an attorney, in my third decade. I can't believe it's been that long. I'm based in New York City and have been a regulatory attorney now for, well, yeah, over 20 years, 21 years, I guess, at this point. I represent fintech companies, debt settlement companies, banks, broker-dealers, technology companies, both in the U.S. and offshore. I'm licensed to practice law in a couple of states here in the U.S., though I've decided to retire a number of licenses just because of difficult time to keep maintaining those licenses. I'm also barred in England and Wales. In addition to practicing law, I teach at Hofstra Law School. I've been teaching there. I'm into my 8th year. I taught a number of courses, including corporate finance law, and I've been consistently teaching the business and policies of cryptocurrencies. And earlier this year, I published a textbook, which is now being adopted by law schools throughout the country, published by Carolina Academic Press. Let me introduce Jessica. Please go ahead.
Hello, everyone. I'm so excited to be co-hosting this exciting webinar alongside two of my favorite people and colleagues. And thank you for the introduction, Felix. I'm Jessica Livingston. I'm the Florida partner of the firm. Unlike Felix, with his 3 decades of experience, I now have 8 years of experience, primarily focusing on litigation, regulatory, and transactional matters. I have represented clients in a litigation capacity, as well as in ADR forums such as JAMS, and in transactional matters in the debt relief space, as well as global financial, fintech, and emerging digital currency sectors. With that said, I'm happy to introduce you to my esteemed colleague and our next co-host, Yvonne.
Hello, everyone. My name is Yvonne Bowser Caballero. You may have seen me on a few of these webinars now. I've been with Shipkevich for a little over 3 years now. I primarily focus on the transactional services side of financial services, debt relief, fintech, and other digital currency sectors. I do a lot of licensing for the firm. So if you've had us help you with any licensing, you're probably familiar with me. And I am excited to be here with you all to co-host this interesting webinar.
Thank you, Yvonne. Thank you, Jessica. And a little plug, I'm actually going to be doing another webinar tomorrow. I was really generously invited by CDRI, Consumer Debt Relief Initiative, to discuss last week's what I would consider to be a pretty significant and arguably landmark holding by the Supreme Court in favor of maintaining the CFPB's constitutionality and technically the funding as it was established by the Appropriations Clause. Please join me and CDRI tomorrow at 1 o'clock. You can register by emailing me directly or to email Cliff Andrews. Cliff's email is below, cliff@debtreliefadvocate.com. Hope you can join. I think it's going to be an exciting discussion about this case and what to expect after this case on the debt settlement industry and in the next few years. So this is the first webinar that Yvonne and Jessica have done together. The last time the three of us have actually been together, we're together in the same room when we were doing our in-person annual workshop on the West Coast. Typically, when we do these webinars, we do them in pairs. Either I do it with Yvonne or Jessica. But this is a very interesting subject matter. It's a subject matter that has come up over and over again in our representation of clients. And we were ultimately asked by a number of clients to do a webinar on this subject matter. And it's fascinating on for multiple reasons. First of all, it's just such a recurring issue that it's would be difficult not to discuss it from a purely educational point of view. And I should probably say that the discussion we're having today is for educational purposes. It's not meant to be legal advice. My goodness, I sound. We have a number of regulators on this webinar who are listening in live, and I should almost say, like, the opinions that you hear are not those of the agencies. No, they're not. But the reality is this is for educational purposes only. I'm happy to obviously discuss this on individual basis, since clearly there's no one size fit approach to this subject matter to all companies or sector of companies. You should be looking at this subject matter on an individual company basis. I just want to be very clear. And the second point is we're limiting this discussion solely to the debt settlement space. The discussion of oversight of companies where you have a principal and a lead gen, right? A company, an operator, whatever it is, could be a lending company, could be a fintech company, a crypto company, a bank, and a lead gen company. Obviously could be quite vast. And the purpose of this specific webinar is only discussing the debt settlement space, but excluding law firms. And this is why you see that asterisk. The discussion is limited to operators. It's not extended to law firms. We're not including discussion of how this would be as what's commonly known as the legal model or legal plans or anything else involving law firms. I do not want to discuss that. And the reason for that is that law firms are generally, they're not generally not subject to licensing requirements. That's one. And second of all, there's a body of law in each respective state. There are professional responsibility rules that govern law firms, and you have to look at case by case basis, state by state basis, where that law firm is operating. I'm happy to do a webinar in the future how this would be applicable to law firms, but for this discussion only, we're not discussing law firms. So we are solely discussing an operator, right, which is a debt settlement company, and a front end. And just for the sake of this discussion, when I'm referring to front ends, it's an industry term. That's a lead generator or a marketing company, a lead generator and a marketing company. When I'm using the term an operator, right, that means a debt settlement company. That's an entity that acts as an intermediary. That's an entity that operates to negotiate debts, right? Front ends don't negotiate debts. They market, they generate leads. Operators negotiate debts with creditors on behalf of consumers. I just want to make sure that there's a clear distinction, and we're going to go into that distinction, particularly in Yvonne's portion of the presentation. And it's very, very important to make the distinction right now, operators versus front ends, okay? So first, we want to look at what is that extent, what is the amount or the magnitude of oversight between a debt settlement operator and the front end, right? That subject matter comes up very often. We represent both operators and front ends. I've been in this space now for 10 years, and I deal with many different in-house GCs or CCOs, and there are always questions. Well, how much oversight do I want to have? Do I need to have? And sometimes there's a lot of back and forth because sometimes the view is I want to have as much oversight as possible, or I want to have as little oversight as possible. What is that happy medium? What is that right medium, right? So we're going to discuss that. We'll try to answer that question. And we also represent front ends, right? We represent a significant number of front end companies that do lead gen for operators. And so the question is, well, how do I maintain my independence, right? I'm operating my own lead gen company. I'm not an operator. I don't settle debts. Okay. I don't deal with consumers. I don't represent consumers when it comes to negotiating debts. How do I maintain that independence? And at the same time, do it in such a compliant way where someone like an operator doesn't need to constantly breathe over my, over my neck, look over my shoulder, what I'm doing. So what's that happy medium? How much of that flexibility can I maintain in maintaining that independence? Jessica will talk about some of the federal law application, and we're also going to limit that discussion only to the telemarketing sales rule and the TCPA. And the reason we're limiting it only to those two federal statutes is specifically for a reason. Obviously, other federal laws, and Jessica will talk about that in her presentation. There's UDAP, there's FCRA, there's CROA. I mean, the list could go on and on. We don't want to go into every single federal statutory body of law. One, because we technically looked into them. Second of all, it would be extremely time consuming. We're hoping to get done in 1 hour. This might be one of the longest presentations that we've had. The last thing I want to do is lose your attention. So we're limiting it to two. And I think these two are also more commonly day-to-day sort of two federal bodies of laws that we interact with, and both operators and finance interact with. Then we're going to go into whether operator licensing should be required at front ends, and that's something which is going to carry over from very briefly from our discussion we had at our in-person event. And the reason it does go hand in hand with this specific discussion, and the reason for that is the ultimate question is, there's a view out there, and it's just a view. It doesn't mean I agree with that view. I probably don't agree with that view. There's a view if somebody's licensed in a licensed capacity, that means that they are responsible. And if I'm doing business with somebody that is also a licensed individual, licensed entity, then I don't have as much liability. And I want to be able to compare and contrast how that is not truly the case. Your liability could attach regardless of whether someone is licensed or not. And Jessica will also talk about the regulatory and legal precedent. So even though you see 4 bullet points, it's quite a lot to cover, and we'll do our best to go through these. Now, what you see here, you see 5 areas of issues that we want to cover. And you're going to see these 5 issues at the very end of our presentation, and you're going to have all of our feedback. So if you stick until the very end, you'll hear all 3 of us respond to these 5 issues. How much oversight is required? What type of oversight is required? When does the oversight start and how much does it continue? How does it continue? What is required from regulatory or legal perspective? Would it matter front ends or licensed operators? Now, so if you stick until the very end, we will be answering these questions, and you'll be getting answers to that. So what are the possible oversight scenarios? Now, obviously, there are many different scenarios. Let me be very clear. You could have many different oversight scenarios. For the purposes of this presentation, I wanted to make it as simple as possible. And so what we've done is we created 3 simple options, right? Scenario 1, you have an operator on your front end and you have a wall between them or a line between them. Or you could arguably say an arm's length relationship, meaning an operator operates independently, a front end operates independently, but operator doesn't oversee the front end. Let me give you an example, right? Because probably some of you are asking, oh, that doesn't make sense. At what point would a front end operate independently? And as I mentioned early in the presentation, when I use the word front end, I mean a lead generation company, lead gen company. And unfortunately, when people think of front ends, they immediately obviously think of debt settlement. So I'll use a debt settlement example. One of the largest marketing companies in the US for selling leads is Martindale Nolo. For those who are lawyers listening to this, you're pretty sure you're familiar with Martindale Nolo. They sell leads to lawyers. Now, I know I said that I will not be discussing how the oversight applies between a lawyer and a front end. No. But Martindale Nolo sells leads to non-lawyers as well. I don't know if you know that. You could buy debt settlement leads directly from Martindale Nolo if you're an operator. That's perfectly fine. In fact, about a decade ago, I remember even reviewing an agreement for one of the operators I represented, looking to buy leads. I think the leads were not terribly expensive at that point, and they were paying per lead from Martin and Noah. There were debt settlement leads. And so the lead would come in and they would say, person's name, type of unsecured debt, and you would have debt amount, and his or her location, area, and so on. And you could pick the state location where you wanted to buy that lead. Now, an operator in that case would have absolutely no oversight over the front end, absolutely none. Martin Nolo, which is a sizable company, would say, hey, you want to buy leads from us? Here's a contract, pay us money, prepay us, we'll send you leads. You don't get a chance to, there's no such thing as we want to do due diligence on you. We want to, you want to do diligence, look at our websites. There's no such thing as we want to see how you're marketing, you could see the websites where they're marketing, but you don't get the chance to look at pay-per-click and any of their proprietary information. So that's your example of the first scenario, okay? Scenario number two is you have some, right? You have a little bit of shaded area right there, right? Where you have an operator that is entering into a relationship with the front end, and during the course of the relationship will have some oversight, and that oversight could be anything from, we want to look at your marketing materials, whether before they're published or after they're published. We want to see your scripts, some type of, and again, it's a case by case analysis. I want to be very clear, but some type of analysis, right? Some type of review, some type of audit that happens. And the third scenario is where there's a lot of oversight, where we want you to sign away some kind of an acknowledgement. We want to get your audit. We want to get samples every week. We want to see, scripts on weekly basis. We want to see letters. We want to be able to talk to your staff. I mean, the shaded area is very, very high, right? You see, there's a lot of overlap, and there's, the front end is not as independent, and in the front end, essentially has less flexibility, right? And so the question comes down to, when you look at these three, and obviously the amount of gray, the level of gray could vary, right? It could be higher or lower. And again, this is supposed to be very high level visual representation. It could vary. And then there's also a question: at what point should this level of review be done? Is this level of review be done prior to entering into relationship, during the relationship, or both, right? And again, this is something to also keep in mind. So these are the three possible high-level scenarios. Again, this is a very complex subject matter, and obviously this could turn into easily a one-day workshop if you really wanted to. So I wanted to just give you high level, just some food for thought as we progress. Okay, Jessica, I'm turning it over to you.
Yes. Okay. I'd like to start by saying I agree. This is a very complex area of law, an issue with countless sub issues. So, but we're trying to focus this webinar primarily on the supervisory role and oversight by debt settlement companies with respect to their front end marketing entities. So at this point, I'd like to narrow our focus and start by taking a closer look at some of the relevant statutes that govern this space. We're going to start, like Felix mentioned, with the TSR and then go into the TCPA. So there are other areas of law which Felix mentioned, like CROA, FCRA, UDAP, and not to discount those other bodies of law, but I simply want to explain why I'm focusing and discussing the TSR and the TCPA. So I'm focusing on these two statutory frameworks because they're more widely used in this field. They're more widely discussed with regulators, clients, compliance departments, and even with negotiating contracts and looking at the rising litigation in this space. I don't know if any of you are familiar, but there's rising litigation in this space. But for the sake of time, I'm going to make this section fairly short by focusing on the TCPA and the TSR. Let's see. So the TSR contains language that extends to third-party relationships, which could apply to anything so long as there is substantial assistance of an entity that violates the TSR. And these slides are just for convenience. I'm not going to read from them verbatim, maybe part of the case law, but this is just, we can provide materials after the webinar. I'm going to give you some commentary to go along with what you're reading. But substantial assistance is a broad term that could apply to anyone, payment processors and other entities. And while I did not find any express statutory requirements for debt settlement companies to supervise or oversee their marketers, front end, or otherwise under the TSR or TCPA, there is extensive case law, which I will discuss later, and legal precedent that discusses extending liability to sellers for the acts of their third-party telemarketers or front ends based on theories of agency and vicarious liability. So this slide is really just to show you familiar terms such as sellers and telemarketers, substantial assistance prohibition, and the fact that that I did not locate or review any oversight or supervisory statutory requirements under either of these legal frameworks.
Thanks, Jessica. So why don't
You're
we take a
welcome.
look at another industry? And I want to be able to explain to you why we're looking at the statutory provision first, right? And for those of you, again, who are lawyers participating in this, we always start with the law, right? We don't go into case law. That wouldn't be the right way to start. So, as Jessica mentioned, by just focusing on TSR and TCPA, and she gave you the reasons why we're starting with these two bodies of law, there's nothing specifically that creates that agency relationship, right? And generally speaking, not every law will create that agency relationship. Some laws do, but not all of them, but some do. In certain regulated industry, there's a direct agency relationship that's written into the law. And in specifically, as I'll give you an example, we do a lot of work in the broker-dealer space, in the commodity space. Before founding my firm in 2011, I was a general counsel of a commodities and futures brokerage, and we were under the purview of the CFTC. We're a member of the National Futures Association. I deal with the NFA and the CFTC still on a regular basis. And the NFA, which is the self-regulatory organization under the CFTC, right? Don't view it as a trade association. It's not. It's actually it's a regulator that was created to assist the CFTC to oversee the commodities and futures industry, actually created a body of law to require member firms to oversee other member firms who actually introduce them business, right? They actually introduced them business. So, for instance, when I was a general counsel of an FCM, which is a future commission merchant, future commission merchants was introduced business by introducing brokers, and introducing brokers are registered entities, right? Think of them as front ends. That's exactly what front ends do. So IBs, in order to introduce business to FCMs, had to be licensed with the NFA and the CFTC, right? There was a registration category created for them specifically by the Commodities Exchange Act. There was specifically bodies of laws written by them, by both the CFTC and the NFA. And, right, just to kind of compare and contrast, this is the supervision rule by the National Futures Association. I know you see the word association, but it's not an association of what you typically see the word association. It's actually a regulator. It is an association, but it's a different type of what you typically see in the debt settlement space as an example. But you see, each FCM, IB, CPO, CTA, I'm not going to go into the specific of those acronyms, members shall diligently supervise its employees and agents, right? And an IB, right, which is like a front end for the debt settlement space, would be an agent, right, for the FCM. So IBs would have to be regulated, right? So here's an example where you have statutory framework, regulatory framework that requires entities to be actually regulated. They have to be licensed. There's a body of law created to be licensed, right? And that body of law specifically says, unlike in the TSR and unlike the TCPA, right? they specifically says you have to supervise your diligently supervise your employees. Of course, we didn't get to the case law yet, right? We will get there shortly. So just please bear with me, right? I'm just looking at the statutory or regulatory framework as it's written, right? You see that you specifically have, and I obviously added emphasis here, that you have to supervise your agents, okay? Just to compare and contrast to a different industry. So does it matter if the front end is registered as an operator? Sivan, on to your favorite topic.
All right, everybody. So, big question. Does it matter if the front end is registered as an operator? So, before we tackle this question, I want to look at the federal language within the TSR. So, what does the telemarketing sales rule say about sellers and telemarketers? So, the rule generally applies to for-profit sellers of debt relief services or, backends or operators, and telemarketers for debt relief companies or front ends. And the telemarketing sales rule goes on to provide distinctive definitions, for each of these players within the debt relief service space. So you'll see here, a seller is defined as any person who, in connection with a telemarketing transaction, provides, offers to provide, or arranges for others to provide goods or services to a customer. Whereas the telemarketer is the person in connection with telemarketing, initiating or receiving a phone call to or from a customer or donor. So you could similarly apply seller as just distinctive as operator, and a telemarketer as the front end here. Most of the provisions of the telemarketing sales rule apply to both sellers and telemarketers. And they also have distinctive statutes that only apply to certain sellers or certain telemarketers. In addition, as Jessica previously mentioned, there's certain parts of the rule that apply to those that provide substantial assistance or support to sellers or telemarketers. And substantial assistance can include obtaining and selling leads or the contact information of a potential customer for another company. So,
Sorry, I guess this was.
So let's consider the question, are front ends required to be licensed as debt settlement companies under state debt settlement statutes? So we looked at the federal. Clearly, there's a distinction between a front end and an operator, but what do states have to say here? So we're going to consider the statutory language for a few states here. A couple of these states you may or may not have heard me speak on and Felix speak on at our conference. But we're going to look at who is required to be licensed under these state debt settlement statutes. Are the front ends debt settlement companies provider or debt settlement companies or providers? Do these front ends provide debt settlement services? And do front ends provide any negotiation or obtain settlements on behalf of consumers, or are they acting as an intermediary? So we're going to look at the statutory language on all of these. So starting with Utah states that a provider may not provide debt management services to an individual who it reasonably should know resides in the state, et cetera, unless the provider is registered under this chapter. So we go to look at the definition of provider, and here provider means a person that provides, offers to provide, or agrees to provide debt management services directly or through others. So a lot of times we find the language that may trip some people up here is the offers to provide. Now, the lead generator or telemarketer or front end in this case is distinguished from a provider because the lead generator isn't offering to provide any sort of debt management service. So here we go to the definition of debt management service. Debt management service means acting as an intermediary. The front end never acts as an intermediary between the individual or the creditor. The front end merely connects that consumer to the provider who offers to provide their debt settlement services. And in further support of this, in Utah, we actually see a distinctive definition for a lead generator, showing that there's a clear divide between what it means to be a provider or an operator and what it means to be a lead generator, telemarketer front end. And they're actually distinguished further in the statutes in multiple sections under the Act regarding what prohibited conduct is and administrative remedies, et cetera, et cetera.
If I could add a couple of thoughts and comments here. So the first comment is Utah has arguably one of the better written statutes involving debt management. It's very clean, and it has definitions. I like the fact, right, as a regulatory attorney, that I have definitions like provider, right? We're going to move on to the next two states that we use as an example, and particularly when we discuss Illinois, Yvonne and I will give an example of how in Illinois the term provider is not defined. By the way, in some states, the term provider is defined. I don't know why in some they decided not to define it, but the term provider should really, like in Utah, have been clearly defined and should have been defined across all state lines. It doesn't make sense. The second distinguished characteristic of this statute is there's a definition of lead generator, right? There's a clear and concise and conspicuous definition of a lead generator. And in other state statutes, well, it's not as clear, right? I like the Utah statute, and that's one of the reasons why we're using it is because it's pretty clear here. So just wanted to provide those comments.
Now, moving to our next state, Pennsylvania. Before moving to the statute, we're going to start with a little bit of the legislative history here. So when adopting this act, Senator Kim Ward wrote in one of her memos that this legislation would adopt provisions of the final rule to take effect in 2010 and address a glaring oversight of the rule. It would cover providers not regulated by the telemarketing sales rule and not engaged in telemarketing and not engaged in interstate commerce and nonprofits. In addition, it would require debt settlement providers that negotiate debt settlement agreements on behalf of Pennsylvanians to obtain a license in Pennsylvania. So this is just very clear language from, the legislative history of the act that it was their intent to regulate and require to be registered or licensed providers that negotiate debt settlement agreements on behalf of Pennsylvanians, those acting as intermediaries, actually providing debt settlement service, not merely a telemarketer or a front end that is providing, lead generation service. So looking to the language of the Pennsylvania statute, it may or may not cause, some confusion as to who is required to be licensed. However, if you break it apart like we did with Utah and you look at the legislative history, it's fairly clear that Pennsylvania intended only providers to be licensed under this act. So what does it state here? A provider may not market, solicit, offer to provide, or provide debt settlement service for a fee or other consideration to an individual in this Commonwealth unless the provider is licensed. So if you break this apart, does a front end market to provide debt settlement service no, the front end doesn't provide the debt settlement service. It's marketing the provision of a debt settlement service by a provider. But it's not offering to provide the service for consideration to consumers in the Commonwealth. Because what does a debt settlement service mean? Again, here we see debt settlement service means services as an intermediary. Front ends do not act as intermediaries between the consumer and their creditors. That is the purpose of the operator.
And also, the reason where Yvonne is geeking out on all this, right, and is really going, you know, deep into every single word, and that's exactly what Yvonne does, and this is exactly what we do when we're discussing it with regulators. You have to look at every single word in the statute, right? There's a reason why it's there. And when it's not there, then you have to go back and you have to look at the legislative history. That's why it's there, right? I mean, that's exactly what, legislative history. If it's available to you, you should be looking at what was the purpose that this specific legislation was introduced, right? Um, Unfortunately, not all legislative history on the state level is kept as well, and all the records are kept. So believe it or not, we're dealing with a state-related issue right now, and just the state records in one particular state are just not well kept. I'll talk about in a second, but this is exactly what we're nitpick every single word. And when the statute is still unclear, right, you have to look at the one, what was the statute intended to do, to what is the legislative history meant to do if there's legislative history, right? And three, whether there's any precedent, right? And we didn't find any precedent in the state of Pennsylvania, right? You look at any consent orders, you look at any prior actions, you look at anything that specifically has any adjudicated legal precedent. Anything else I missed, Yvonne? Anything else you want to say?
No, I think you hit it all. Yep.
Yep. Okay. So let's go to the more complicated one.
All right. So here we have a statute that, generally speaking, would appear to require any person who solicits for or acts on behalf of any person or entity engaging in or holding itself out as engaging in the business of providing debt settlement service to first obtain a license. So here the language really appears to be written very broadly here as to what they categorize as a debt settlement provider that is required to obtain a license under this act. However, if you look to the original purpose of the act written in Illinois, you see it's to protect consumers who enter into agreements with debt settlement providers and to regulate debt settlement providers. The consumer, the privity of contract, when you have a relationship between a front end and a operator and the consumer, is between the operator and the consumer. Once the front end is removed from that contract to provide that debt settlement service, and is removed from that agreement. So looking to that, it's easy to say, perhaps this was written a little too broadly, and actually looking at, like Felix mentioned, to enforcement actions. And, we haven't found anything that would suggest that Illinois is coming after, front ends for failing to obtain a license. And unfortunately, unlike Pennsylvania, that had some really well kept legislative history, like Felix was saying, Illinois didn't keep as clean of a record of legislative history, and there was nothing from my research that I was able to find to give us a little bit more guidance. But if you look at that purpose and you look at how Illinois has come to enforce this act in the last decade or so, that it has been in place, there's nothing really here, generally speaking, that would suggest that Illinois is seeking to have these telemarketers or front ends registered. other than this very broad language included in the statute.
Exactly. And Illinois is not exactly in a state that's not populous. It's a very populous state. It's a big state, um, uh, and and look, I encounter legislative ambiguities all the time. I probably wouldn't be in business if I didn't find legislative ambiguities or regulatory ambiguities. I mean, the reality is the Illinois law, and I actually spoke to a pretty major firm that we call counsel with on a subject matter, different case, but still involving this specific statute. They probably didn't do this correctly in subsection 2, and the fact that Illinois has probably had hundreds of thousands of consumers go through um, the settlement program, and they never tried to enforce this. Seems to me that they probably never meant to include those are front ends. Now, if the argument is, well, then I read the law and it says solicits and acts on behalf, I could tell you that it is not uncommon. It is not uncommon if you are a true, um, if you read the law as it's written and which is fine. Obviously we have, listen, we have Supreme Court justices that read the Constitution the way it's written, and it's perfectly fine. I'll talk about that tomorrow at CDRI's webinar. But we have a number of very conservative Supreme Court justices that literally read the Constitution and interpret their constructions. Right? They they don't try to stretch the definition. Then you have to look at other states, right? We at the end of the day have a union, and the question is, why do the other states not enforce this? Why do the other states have the definition of a provider or lead gen, and why does your state not have it? It is an interesting issue to litigate. I wonder if it ever would become litigated, but I wanted to kind of give you the 3 different variations: Utah, Pennsylvania, and kind of Illinois, sort of the outlier in all of this. Thanks, Yvonne. Jessica, back to you.
Okay, thank you, Felix. Okay, so going into the case law and the precedent that I previously mentioned, I think it's important to note that while I found no recent case law that specifically holds a debt settlement company liable under agency theories, like I previously discussed, I think it's helpful to compare to other industries in which courts have analyzed the same type of agency liability that could stem from violations of the TSR or the TCPA. And additionally, I want to discuss at least one case that analyzes substantial assistance under the TSR. I think that's the next slide. Okay, so the FTC versus Day Pacer. Okay, so Day Pacer in this context, in this case, was a telemarketing company that makes calls to generate consumer leads to sell to for-profit education companies. And the court found that it provided substantial assistance and support to other telemarketers that allegedly were acting as their agents and in making prohibited calls. So I just want to make a quick point that even though Day Pacer is considered a telemarketing company under the TSR, that telemarketer means any person in connection with telemarketing that initiates or receives telephone calls to or from a customer. So an operator could be deemed a telemarketer if they have that as part of their business structure. I just want to make that point. And in this case, the FTC held that that there was substantial assistance in that there was more than mere casual or incidental dealing with a seller or telemarketer. And the fact that went to that first element of substantial assistance is that the defendants paid the other telemarketers to make calls or transfer leads to them. This is a really important fact because paying, there's at least one Illinois court that says that there's no better showing of substantial assistance than to pay an entity for violating the TSR. And as far as the knowledge element for substantial assistance, this court found that the defendants continued to pay and work with the entity even after receiving repeated complaints from the schools, consumers, and compliance monitoring companies that it was calling do not call numbers without consent. So the violating acts in this case was to make calls to individuals that were on the do not call list. And I just, big picture, I think that this case demonstrates that where a telemarketer pays a lead generator and receives complaints about violations of the D&C list prohibition under the TSR, it may be time to reevaluate the relationships, because courts like this court could impose statutory liability or individual liability under the substantial assistance prohibition. And that being said, I don't know if you disagree, Felix, but I think this case tends to advocate for some level of oversight of a front end or lead generator, especially when you're paying the front end for lead generation and marketing services. So this is a very complex subject, and I'm really focusing on tracing the liability that courts are imposing under the statutory framework, here the TSR.
Absolutely. It's clearly a case where you can't willfully close your eyes, particularly if you have customer complaints. So even if you said they want to have an arm's length relationship, that's fine. But if you obviously have customer complaints from a third party lead gen company, you have to take some action to look into see what's happening, right? You can't just ignore any potential issue that may arise, even a red flag that may arise. So you might have to do something more than just to continue business as usual.
Mhm. Agreed. So the next slide and the rest of the slides, I'm actually focusing on a huge issue that's brought up in these contexts under the TSR and TCPA, and that's agency liability. This first one is the strategics case that's ongoing, but it's legal precedent in some form or fashion for several reasons. One, it lays the groundwork for courts to find sellers liable for prohibited acts of front ends. And two, there's also potential liability for individual officers and owners to be held liable, or at least to be hailed to court for alleged violations of the federal law by third-party marketing companies. That's agency in general. This strategic case specifically analyzes facts in which the court did not find an agency relationship between a debt settlement company and its notaries, so as to try to impose liability on the notaries. While there were some typical hallmarks of agency that I've highlighted in this slide, the direction and control by the debt settlement company, this court found that the notaries lacked substantive knowledge about the debt settlement company's program, and that the notaries did not actually sell any debt settlement programs or discuss the programs with potential clients. So under these facts, the court found that there was no agency or likely to be found an agency relationship between these individuals and the debt settlement company. I wanted to show this case because there was at least one case that spoke to debt settlement companies in the context of agency liability. But the other cases are more informative, even though they're not directly on point with debt settlement companies. They go really into the sub-elements of agency with front ends. Okay, so in this case, the Partners in Healthcare Association, these are facts tending to show that the marketer is an agent. In this case, the court found that the seller of discount medical cards was vicariously liable for the acts of several third-party marketers, which was demonstrated through marketing agreements. This court focused heavily on the actual agreements between the seller and the marketing companies, specifically that the marketing agreements required that all sales, marketing, and other promotional materials must first obtain the seller's approval. I've seen this in practice, but this is a case that I just want to highlight because that level of oversight and control can, as we see here in this case, tends to show an agency relationship, which can extend liability back to the seller. Additionally, the court found that the seller had opened merchant accounts for the marketers and handled all the billing and payment matters, and customer support and all materials related to the discount card being sold. So there was a very close relationship. I would put this under the second or the third Venn diagram that Felix was mentioning earlier. So under these circumstances, the court found that the seller's level of control over the third parties was sufficient to find an agency relationship. So, okay, this is the Bronsky case, and this is really an explanation under the TCPA that explains vicarious liability, um, actual authority, and apparent authority. So it's the same whether it's between the TSR or the TCPA, but I found this slide informative just to educate you on what are the elements of agency and vicarious liability that I've been talking about. So the TCPA allows for vicarious liability under traditional agency theories. So actual authority is one type of agency liability. And the classical definition of agency contemplates, and I'm reading from the slide, the fiduciary relationship that arises when one person, aka a principal, manifests assent to another person, aka an agent, that the agent shall act on the principal's behalf and subject to the principal's control. So if we break this down, the seller, in this case, the debt settlement company, could arguably be called a principal because the agent, here, the front ends, would be acting on behalf of the debt settlement company and subject to the debt settlement company's control. This type of liability, you know, would fall under the third Venn diagram where there's just a lot of control over the marketing entity. And potential liability under general agency related principles extends beyond classical agency because there's another level. If a court doesn't find actual authority, the principal, the debt settlement company, may be liable under circumstances where a third party has what's called apparent authority. So such apparent authority holds a principal accountable for the results of the third party's beliefs about an actor's authorities to enact as an agent when the belief is reasonable and traceable to a manifestation of the principal. For example, because we need an example here, a seller may be liable for the acts of another under traditional agency principles if it ratifies or encourages or continues the conduct, gives the green light, those acts by knowingly accepting their benefits. Such ratification may occur through conduct justifiable only on the assumption that the person consents to be bound by the acts of the legal consequences. So there's the requirement that the principal or a debt settlement company is aware that the front end has assumed some type of authority to act on behalf of the debt settlement company, and the debt settlement company enjoys the benefits and does nothing to prevent the front end from acting. So I just wanted to go through this. I know I'm geeking out, but I just wanted to go through this just to educate you all on what I mean when I say agency liability.
Yeah, and let me add, and if you made it this far, because you appreciate this level of geekiness from our part, I thank you. If you didn't, you're actually missing the crux of it. Because if you're gonna call me or email me and saying you never got to it, Felix, you never got to it, I listened to it, you never got to minute 57. So for those of you who actually I see are still listening to it, you're gonna get the bottom line here. Here's the deal, right? Because I could tell you I love the people who drop off after 15 minutes and then they said, oh, I participated but I never heard. So the reality is this. when we represent many front ends and we negotiate deals with operators, the operators, outside counsel or in-house counsel, and this happens all the time, and this is kind of the recurring issue. Well, we want to know everything they do. We want to, stick our hand in their business and know everything they do because we're responsible for them. And the discussion is, why do you want to know everything they do? They're legitimate elites for us. Well, we're responsible for them. Okay. Well, if you're responsible for them, then then you're going to bear responsibility. No, no, contractually, we don't want a responsibility. No, 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 no. They're going to have to indemnify us if they do something wrong. Well, you can't have it both ways, right? It's either you're going to have to try to give flexibility to my client, which is the front end, or if my client is going to be the agent, you're going to have to accept the responsibility. You're going to have to take, since you're the principal, going to take the responsibility, because at the end of the day, the reason I gave you that example from the commodities and futures side, which I'm very familiar with, if you're the principal and if you have the agent, you're going to be responsible for it. So you can't say, right? So then I asked them, why do you need to know everything? Why do you need to know everything? That's fine. You need to obviously be responsible. You need to obviously go in and be, no one's saying that you have to duck your hand in the sand or willfully close your eyes. But why do you need to know everything that my client does, right? They're a lead gen provider. An example that I gave earlier in this presentation is Mark Nellanola. By the way, I don't know any stock about Nellanola. I don't have any friends or family that works on Nellanola. I'm just giving you this as an example, right? So what is that happy medium? Because many backhands believe, well, we want to know everything that you do front ends, but then you're also taking a lot of responsibility, regardless what you covenant, because from a purely legal regulatory responsibility, you can't covenant away your obligations, because that's what the law says. That's what the legal precedent says. It says you're the principal then, right? And that's what Jessica and I constantly tell the other side. And again, when I represent the back ends, I said, okay, let's figure out what makes sense. When we're the back end, we represent the back end. I don't want to know everything the front end does. I obviously want to make sure the front end is not doing anything that's not kosher. I don't want to make sure that we do the due diligence ahead of time. Absolutely. But at the end of the day, the things that I sometimes see when I represent front ends from back ends legal team is astronomical. And I'm sure I have people sitting here, because I know I have general counsel, some from back end saying, well, that's ridiculous. I need to know everything. There you go. That's the case law. This is federal court. This is March 29th, 2024. And by the way, just because it's TCPA, this vicarious liability, let me tell you something. It doesn't matter. It applies to vicarious liability. If you intend to that overshadow a majority of front end's operation, that vicarious liability is going to overshadow as much of it as possible. Again, this is not legal opinion. This is for educational purposes, but this is a case that's very recent. It's not even 2 months old. And it creates that responsibility because you're controlling the front end. Okay? Let's continue.
Yes, in the next case, speaking of examples, if I can go through this, I'll go through it very quickly. So this is a federal court out of Texas that found that the marketer was an agent of the seller, where the seller had, let me see, the right to provide interim instructions to the telemarketer in the form of script modification. The seller provided the script to the telemarketer to use. The seller had authority to terminate the relationship unilaterally, where the telemarketer did not have the ability to terminate the relationship. And the seller only permitted the marketer to sell its, in this case, the dental discount plan, if they provided the seller with detailed information about its marketing strategies. And finally, the marketer was required to obtain prior express written approval from the seller to market the seller's products. All of these facts showed a high level of control over the marketer that sold the seller services, which goes to this vicarious liability as an agent. And the court held in this case that it had personal jurisdiction over the seller because the marketer was an agent of the seller, And what personal jurisdiction essentially means is even if your marketer is performing these services that violate, in this case, the TCPA in a state that you don't operate in, you can still be hailed to court as the seller if the marketer is deemed an agent in this way. And the last case that I want to go through is the Gale case. This is an instance in which there are facts tending to show that the marketer is not an agent. So the other side of the coin. So in this case, the seller's website stated expressly that it is responsible for the sales, marketing, and customer service of its business in the US. That is something that the plaintiff was trying to hang his hat on. Despite this fact, the court looked to the level of oversight and supervision that the seller had over the telemarketer. And here, where there were no alleged communications between the seller and telemarketer, much less any that acknowledged that the marketer would act as this for the seller on behalf of the seller as an agent, and where the seller had no specific knowledge about, in this case, the prohibited text messages under the Florida mini TCPA. The court found that there were insufficient facts to allege that the marketers acted with apparent or actual authority as a seller's agent. So this is a good example, even where on your website, you can say, for instance, a debt settlement company's website, we're responsible for all marketing materials. The facts came down to what was the level of oversight and the communication between the marketer? What authority did this marketer have to solicit individuals or consumers on behalf of the marketer? And they're not mentioning it, but I'm sure if there were consumer complaints, that would be part of the analysis as well. But I just wanted to at least give one case of facts tending to show that the marketer is not an agent.
And so we're back to, thank you, Jessica. We're back to the previously asked questions, as I promised, right? Let's try to answer these 5 issues. And let's see, after getting all this information, if after geeking out on all this case law and statutory framework, and for those of you who are still here, you've made it this far, congratulations. So how much is oversight is required? So I'll start with that one, and I'll turn it over to my teammates. And I hope you'll get a chance to see this is how we work. We work as a team. I think, first of all, obviously, it's on case-by-case basis. It depends on what type of, if you're backend, if you're an operator, it really comes down to what are your resources to do this. I mean, if you really, I would never recommend to have somebody complete an arm's length relationship, not having any involvement, but I never like to have anyone having this knee deep, compliance review of someone that would be arguably viewed as control. And create this agency relationship. So depending on your resources, depending on how much compliance or regulatory staff you have, we would come up with some kind of a plan that has reasonable attention to, compliance with TCPA and obviously any type of promotional material, so that you're also not violating UDAP. But it has to be reasonable to your business. When it comes to front ends, and by the way, I'm probably going to just touch upon what type of oversight is required, because I think you could probably answer both of these together, not just how much, because it's kind of answering both of these together. I think with front ends, first of all, I always encourage them to be independent. Now, independence doesn't mean that you're going to have to take liability and responsibility. You can't say, well, I want that responsibility. I don't want somebody, breathing down my neck, but at the same time, if something happens, I want somebody else to pay for it. No, you're going to have to be responsible, and you need to make sure that you're compliant, because if you're not compliant, that's a problem. The other thing is, a lot of this due diligence should and must happen before a contract is signed, and not before a contract is, not just during the relationship, right? During the relationship, again, it's a case by case, depending on how much business is being introduced. But I never like these personally, when I represent front ends, I never like these very boilerplate materials like this is how many calls, this is how many emails we want to see. This is like it just doesn't make sense because it depends on how much business. And do you really need to see the calls? Shouldn't it be based on customer complaints? Because listen, you're getting a lot of customer complaints, you should be investigating, but it shouldn't be just on, well, we have a right to all of your materials at any point at any time. That's also not correct. And in fact, it creates a lot more liability on you. So that's sort of my comment on the first two questions. Jessica, Yvonne?
I just want to point out that as far as the statutes are come into play and even the case law, there's no per se requirement, like you mentioned, Felix, and other areas that are not this space. But there are provisions that may apply to sellers through common law agency theories of liability, like I keep geeking out over. And this is primarily based on the statutory language that prohibits sellers to cause a telemarketer to perform a prohibited act, or then entity on whose behalf a prohibited act is performed could be held potentially liable. So there's not an express requirement for oversight. There's just these words, these terms that are used in the statutes that the that the courts focus on to try to trace liability back to the debt settlement company.
Just kind of reiterating a little bit of what Felix and Jess have already said, but really, the amount of oversight required, it depends. Like Felix was saying, you don't want to have too much oversight that could exhibit control, but also, if you have a requirement to include certain disclosures in your advertisements, you should be looking at, if you use a front end for marketing, you should be looking at their advertisements in that state and making sure they have any required disclosures that you have to adhere to. So really, it's going to depend, and it's always a delicate balance between, maintaining independence between companies, but also making sure that, you're not willfully ignorant to any blatant disregard of any certain statutory or legal requirement.
Thank you. So when does the oversight start and how does it continue? And maybe it should be phrased, when does the due diligence start? And I think that is really when you should be doing most of your due diligence prior to entering into a relationship. And that goes for both parties, the operator or the front end. And the relationship, once the contracts are signed, once the relationship is established, is obviously quite important. But I think from a point of liability, that due diligence should and must be done prior to signing the contract. That's when you have ample opportunity to get to know each other and to ask as many questions as you have. I find it always interesting that, again, maybe I'm biased because we do represent many lead gen and marketing companies in the space. And when we get questions from the operators, well, we want to do XYZ once the relationship is established. Well, why aren't you doing this now, right? Why aren't you doing this before the contract is signed? You have ample opportunity to ask us questions, but for some reason, it's always after the fact, and I think that's kind of silly. And I, when I represent backends, I always tell them, look, we got to do due diligence on the front end now. Let's find out what is it they do, how they do things. Let's find out, have they been sued under TCP, how much litigation they have they have any regulatory background history, who are the sales agents, what type of scripts do they use, how do they generally do their business, right? You want to do this now versus when it's signed. Now, when it's signed, again, you have to come up, like I said earlier, in your own fact specific, reasonable compliance that has some shaded, but not overly and not under, right? But in my opinion, it should be done. A lot of it, the bulk of it, should really be done prior to entering into a relationship. I don't know if Jessica, Yvonne, you have anything else to add?
I would speak to the next, what's required from regulatory or legal perspective.
Sure, go ahead, please.
So I just wanted to mention consent orders, because we haven't really talked about that against sellers and debt settlement companies. They seem helpful in some regard as they are precedent, but they're unhelpful um, in terms of this webinar because they don't really serve as guidance or explanation to trace the acts of a third party marketing company to a debt settlement company. At most, various arguments on both sides were likely made privately and are not included in the consent orders, or did not make it into the consent order. It just really, these consent orders focus primarily on violations and conclusory statements. So I just wanted to make a side note about the consent orders in that regard.
Let's move over to the final question. Would it matter if the front ends were licensed as operators? And I already compared and contrasted to another industry that's nothing to do with that settlement. And I give you an example of how, you have licensing in other areas and you arguably have more responsibility. So, Yvonne, what do you think?
Yeah, I mean, generally speaking, it really doesn't matter whether you're licensed or not. You're still gonna have, certain oversight requirements, whether you're requiring your front end to get licensed or you're deciding that, you don't need the front end licensed, for the reasons that we've given. So generally speaking, it doesn't play any part into oversight.
Okay. Yeah, same thing. Yeah, I guess as long as there's no registration category and there's no clear guidance from the state and um, to regulate front ends as operators. And the reality is, of my opinion, has been for quite a long time, is that lead gen companies are not operators, and the law is quite clear on the federal level. It's quite clear on the state level. I see no reason to be beating a dead horse on the subject matter, but even if they were required to be licensed, that the liability, like Yvonne said, wouldn't make any difference. Um, and in fact, you probably would have a separate body of law written, probably that specifically would say that they would have to be supervised. So for those of you who, for some reason, are thinking that requiring them to be licensed is something that would be will help you to alleviate liability, that's a very silly thing to do because that, in substance, it makes no difference, in my opinion. It doesn't make any difference in other areas. In any case, this is the end of our webinar. These are the different services our firm provides. I'll leave that slide up for another few seconds. You can sign up for debtreliefwatch.com for our newsletters, announcement. We provide a lot of free information, educational webinar series to the debt relief space. And of course, a big thank you to those of you who are continuing to return to our webinars, and thank you to Yvonne and Jessica for their tremendous time in researching this topic and putting this together. And for those of you continuously listening to our webinars, we look forward to seeing you again. Hope to see some of you tomorrow at CDRI's webinar. And thank you very much.